All right, let's talk about something that sounds super complicated but is actually at the heart of fairness in our justice system: the Erie Doctrine. Yeah, I know, sounds like a textbook chapter you'd want to skip. But stick with me, because this is all about closing a massive legal loophole that basically created two different kinds of justice in the very same state. So let me just ask you this. What if winning or losing your lawsuit had nothing to do with the facts and everything to do with which courthouse door you walked through? The state court on one side of the street or the federal court on the other? That sounds totally wrong, right? Well, for nearly a century, that's exactly how things worked in America. And that is the mess the Erie Doctrine was created to clean up. Okay, so how on earth did this happen? Well, before 1938, a big case called Swift v. Tyson basically split the legal system in two. See, in state court, things were simple. They used all the state's laws, the written ones called statutes, and the judge-made common law. But if you could get your case into federal court, things got weird. Federal judges only had to follow the state's written laws. For everything else, they could just make up their own general common law. You literally had two different rule books for the same game being played in the same state. And you know, whenever you have two sets of rules, you can bet clever lawyers are going to figure out how to play the system. This gave rise to something called forum shopping, and it's exactly what it sounds like. Lawyers would literally shop around for the court, the forum, that had the rules that would give their client the best shot. It became less about justice and more about a strategic game. And this was the playbook. It was pretty straightforward. First, you needed a case where the parties were from different states. That was your ticket into federal court. Step 2, your legal team would pore over the state common law versus the federal general common law to see which one helped you more. And finally, you'd file in whichever court gave you that sweet home field advantage. The actual facts of the case, suddenly they weren't as important as where you filed it. Eventually, even the Supreme Court had to admit this was, in their words, grave discrimination. And you can see why, right? Imagine a big out-of-state company suing a local resident. They could drag that person into federal court and force them to play by a totally different, and often better, set of rules. But if that local resident wanted to sue their next-door neighbor, nope, they were stuck in state court. The scales of justice were basically rigged from the very beginning.
So, this totally unfair system obviously couldn't go on forever, and the whole thing came to a head in 1938, with a case that you can probably guess: Erie Railroad Company versus Tompkins. This wasn't just another lawsuit. This was the case that was going to bring a century of legal games to a screeching halt.
And this is the sentence that changed American law forever. Seriously, this is one of the most important lines ever written by the Supreme Court. The ruling was so simple, but so powerful. It basically said, look, there is no such thing as a federal general common law. From now on, in any given case, the law you apply is the law of the state, period. End of story. Unless, of course, the U.S. Constitution or federal law is involved. So the big takeaway was huge, just revolutionary. Erie basically told federal courts, when you're hearing these kinds of cases, you have to act like a state court. You have to apply the state's substantive law. That means both their written statutes and their judge-made common law. Just like that, the two-track legal system was gone. But you know how it is in law. You solve one big problem and a new, trickier one pops up. The Supreme Court said federal courts must use state substantive law. Okay, great. But what about procedural law? You know, all the nuts and bolts rules about how you actually run a lawsuit. This set up a brand new puzzle for everyone to solve. And this became the next big question. How in the world do you tell the difference between substantive law and procedural law? Here's a pretty good way to think about it. Substantive law is the what of the case. What are your rights? What are your obligations? Procedural law is the how you file papers, how you argue in court, all the rules of the game. But as you can probably guess, that line can get really blurry really fast. This table actually does a great job of breaking it down. Over on the left, you've got your substantive law. This is state territory. We're talking about things like what you have to prove to win your case, or how much money you can get in damages. Then on the right, you have procedural law. This is where federal rules, specifically the Federal Rules of Civil Procedure, or FRCP, take over. This is all the how-to stuff, how you file documents, how you behave in the courtroom, that kind of thing. Okay, so for years and years, courts really struggled with the gray areas. But over time, a much clearer system started to take shape to help judges make these tough calls. Let's look at the modern rulebook they use today. The real breakthrough came in 1965 in a case called Hanna v. Plumer. Now, Hanna didn't get rid of Erie. What it did was give judges a practical, almost step-by-step guide for what to do when a state rule and a federal rule seem to clash. You can think of it like the official decoder ring for the whole Erie Doctrine. And here's how that decoder ring actually works. This is the checklist courts still use. First, they ask, is this issue clearly substantive? Does it define rights and obligations? If yes, easy, they use state law. If not, they move to step 2. Is there a specific federal rule of civil procedure that's on point? If there is, that federal rule almost always wins. But if there's no specific federal rule, they get to the big question, the heart of it all. If we use the federal practice, is it going to encourage forum shopping or be fundamentally unfair? If the answer is yes, then they have to go with the state rule.
So after all that legal detail, what's the point? It really all boils down to 2 simple, incredibly important goals. These are what lawyers call the twin aims of the Erie Doctrine.
And here they are. First, to discourage forum shopping. The outcome of your case should not depend on which courthouse you're in. And second, to avoid the inequitable administration of the laws, which is just a fancy way of saying to make sure it's fair. Your rights as a person shouldn't magically change just because the person suing you is from out of state. Everything we've discussed, from Erie all the way to Hanna, is designed to protect these 2 fundamental ideas of justice. The whole point of the Erie Doctrine is to make sure the law is about the facts of a case, not the other way around. And make sure that the federal courthouse down the street isn't some secret backdoor to a different set of laws, but just another venue to apply the state's law fairly. So the next time you hear about some huge lawsuit, just ask yourself, is the real fight here about what actually happened, or is it about which rulebook the lawyers are trying to force everyone to play by? Now you know just how important that question really is.